committee meeting on agriculture, land reform and rural development as we continue with the engagements we had on the deliberations of the bill on Animals Protections Amendment Bill, as it was requested by the committee that we invite the Department of Trade and Industry and Competition to come before the committee, as well as that of the Department of Health, so that they can speak to how the bill affects them. The committee will therefore be able to engage with the B bill as soon as the Secretariat has been able to factor that in. We also, honorable members, invited the Honorable Minister, who had presented the presentation on the Ministerial Task Team in regards with Ingonyama Trust. We therefore requested that that should be postponed for another time so that we enable honorable members to engage with the presentation the Honorable Minister had brought before the committee. I will therefore enable the Minister, as she had already presented the presentation to the committee, just to have further input in terms of opening words, and therefore be able to engage with the presentation she had brought before the committee. Allow me, therefore, honorable members, as the program is being put before the committee, we'll take the two presentations from the Department of Health as well as Department of Trade and Industry, dispense with that, and then get into the deliberations of the Ministerial Task Team, allowing the Secretariat to factor the input that we have been able to receive from the two departments, so that when we are done with the Ministerial Task Team input from the Minister, we can revert back to the deliberations on the B bill of the Animal Protection Amendment Bill, so that we can therefore move to the desirability of the bill. Honorable members, goeiemorgen, good morning, dumelang, sanibonani, molweni. Allow me to take this opportunity to invite the Department of Health to present their input.
Good morning. My name is Wayne Ramkrishna. I'll be presenting on behalf of the Department of Health. Our apologies for the late submission of the presentation. So let me get started with checking the presentation. We're just projecting the presentation now. Can you see the presentation?
Yes, we can see the presentation, but can you enlarge the slides as they are all? Yes, thank you. You may proceed.
Okay, thank you. Yeah, thanks. Let's go to the first slide. Yeah, so this is a briefing on the Animal Protection Amendment Bill. And the purpose of this presentation is to provide a brief on the Animal Protection Amendment Bill and the impact on the Department of Health legislation. So The objective of this is to amend the Animal Protection Act of 1962 so as to insert a definition for cosmetic, to provide for a new offense related to the testing of a cosmetic or part of or ingredient of a cosmetic on an animal, and to provide for matters connected therewith. Effects of the Animal Protection Amendment Bill on relevant pieces of legislation that are administered by the Department of Health. In particular, the Foodstuffs, Cosmetic and Disinfectant Act of 1972 will be affected as follows. And these are the proposed insertion of the amendments. Any person shall be guilty of an offense if he sells or manufactures any cosmetic which has been tested on an animal in the Republic. The offense shall not apply to the provisions to an ingredient that may be included in a cosmetic, but which was tested on an animal for a purpose that was not related to the use of that ingredient in a cosmetic. And the third piece is the special defense referred to in subsection 1A, that is sale or manufacture of any cosmetic which has been tested on an animal in the Republic, and it does not apply to the offense. So in terms of impact of the bill on existing regulatory framework, so impact of the existing regulatory frameworks, the Foodstuffs, Cosmetics and Disinfectant Act will be impacted, as the act is enforced by the Department of Health and municipalities by environmental health officials. In terms of position of the National Department of Health, the first ban on animal testing of cosmetic products was started by the European Union. A full ban on both the sale and import of cosmetics that are tested on an animal was done in March 2013 by the European Union. India banned cosmetic testing on animals in 2014. New Zealand prohibited the use of animals for tests of cosmetic products since May 2015. Countries like Israel, Norway, Brazil, South Korea also banned cosmetic testing on animals. So this is a brief background as to the international position on testing of cosmetics on animals. Many countries are trying to bring new regulations, amendments related to use of animals in cosmetic preparation. But this move will protect the animals from unnecessary suffering all over the world. In reviewing the bill, it was necessary to understand the position of the Department of Agriculture, Land Reform and Rural Development, and the Department of Trade, Industry and Competition as well. So the Department of Agriculture, Land Reform and Rural Development, they state that the definition includes products that are meant to improve quality of life of users, personal care and well-being, and should not be considered as beautifying products, such as protecting the skin and health, improving feminine hygiene, and correcting unpleasant odor. So subsection 1, NA, the testing on an animal of an ingredient that may be included in a cosmetic shall not constitute an offense where that testing is for a purpose unrelated to the use of that ingredient in a cosmetic. There is a possibility of bypassing the provision by applying to test an ingredient in a medicine, however, with the hidden intention of using the outcomes thereof to determine the usage of such a product as a cosmetic. So these are some of the challenges that the Department of Agriculture, Land Reform and Rural Development is highlighting, that these amendments can be bypassed. So going further, the cosmetics industry in South Africa directly employs around 60,000 people, and this does not include employment as retail, at retail. The industry contributes 0.1% to the GDP. The total size of the beauty industry in South Africa is about 25 billion at retail value as of 2020 figures, and 19 billion at manufacturing level, and includes cosmetics, aerosols, roll-ons, and personal care. The South African beauty industry furnishes about 150,000 stores, and multinationals dominate the beauty and personal care industry. Over the last 2 years, the cosmetics industry has experienced an estimated compound annual growth of 4.6% and is expected to grow annually by 3.9% from 2023 to 2027. There is currently no technology and expertise in South Africa for alternative methods of testing of cosmetics. In the absence of technology and expertise, the Department of Health, Agriculture, Land Reform Rural Development is saying a ban will result in South African companies having to test cosmetics outside of South Africa at an additional cost and may not be competitive when compared to multinational companies. So the recommendations from the Department of Agriculture, Land Reform and Rural Development include: the Portfolio Committee is advised to consider alternative approaches to the ban on testing as follows. One is the adoption of the 3R principles on the usage of animals in experiments. And the 3Rs are replacement, reduction, and refinement. The amendment or development of legislation as follows, and they provide two options. The first option being to amend the Animal Protection Act by the inclusion of the following clause. Any person intending to test an ingredient on an animal for use as a cosmetic must apply to the minister for permission to conduct such testing. Secondly, the minister must subject such an application to an independent panel of experts in animal ethics, which shall include at least one veterinarian with expertise in animal welfare. And thirdly, the applicant must provide reasons as to why alternative methods of testing are not desirable. The second option provided by the Department of Agriculture, Land Reform and Rural Development is to develop regulations under the Animal Protection Act to address the testing of cosmetics on animals. And secondly, Section 10 of the Animal Protection Act provides as follows. And we're looking at Section 1. The minister may make regulations relating to, under 1B, any other reasonable requirements which may be necessary to prevent cruelty or suffering of an animal. And going down to 1D, generally such matters as are required for the better carrying out of the objects and purposes of this act. Now, going to the Department of Trade, Industry and Competition, Department of Trade, Industry and Competition is still to comment on this bill. So we are expecting to hear their position later on. And it is likely that the bill will have a significant commercial or economic impact on the Department of Trade, Industry and Competition as well. And the Department of Trade, Industry and Competition will likely highlight this. So in conclusion, the Department of Agriculture, Land Reform and Rural Development does not agree with the amendments with reasons including commercial and economic issues as well as labor issues. Provided alternative options, while the Department of Trade, Industry and Competition is still to comment. The bill will affect the Foodstuff, Cosmetic and Disinfectants Act of 1972, and the major impact will be the enforcement of the Foodstuffs, Cosmetics and Disinfectants Act. However, the main stakeholders that would determine the outcome of the Animal Protection Bill are the Department of Agriculture, Land Reform and Rural Development, and the Department of Trade, Industry and Competition. So the Department of Health will support the enforcement of the Animal Protection Act, that is the principal act that is being amended by the bill, through the Foodstuffs, Cosmetics and Disinfectant Act, whether it be through amendments or through regulations, as recommended by the Department of Agriculture, Land Reform and Rural Development. Thank you.
Thank you, Baweng, from the Department of Health on the presentation. Honorable members, let's move straight into the next presentation from the Department of Trade and Industry, so that we can have questions of clarity on both the presentations. Allow me, therefore, to invite the Department of Trade and Industry and Competition. Please proceed. You may put the presentation. Go ahead. Can you enlarge the slide so that we can be able to see? DTI, please proceed. That's great. You may proceed. We can see the slide. Can someone from DTIC please proceed and present? Manyamza, Mamkakaza, are there any people from DTI responsible for this presentation?
Yes, Chair. Mamo Elizabeth.
Mamo Elizabeth, can you please present? Mamo Elizabeth, please present. Mamo Elizabeth, can you present, please?
Good morning, Honorable Chair.
Yes, good morning.
Good morning. I'm so sorry. Technology is not on my side this morning. My apologies. Good morning to you,
these
Chair.
Things happen.
Yes, they do, when we don't want them to. Good morning to you, Chair, and to the committee. And may I also say good morning to Minister Didiza. Honorable Chair, we have a team of 3. First one being Ms. Claudie Stein, and she will do the very first part of the presentation. She's the Chief Director for Chemicals, Pharmaceuticals and Plastics in the DTIC. Then there is myself. I'm Chief Director in the Trade Policy Branch, and also my colleague, Ms. Tembi Mlangeni, who is the expert on the World Trade Organization technical barriers to trade agreement, which is the agreement which we think from a trade policy side might have a bearing here. I should firstly say Ms. Mlamgeni is tied up in an interview and she hopes to be in very soon. So I will do my best to present her part of the presentation, and hoping that she would be able to assist when question time comes. I trust that you could find that in order, Chair.
That's perfect. Please proceed.
First slide relates to the work of Ms. Steyn, so I would like to request that she presents this. Thank you, Chair.
Good morning, Chair, and thank you, Elizabeth, for that. Just to give an overview of the sector so that we can have a better understanding in terms of the strengths, weaknesses, opportunities, and threats that we find ourselves, within the Republic, within South Africa. So just to give an overview here, that South Africa has a well-structured manufacturing sector, and we have a large number of small manufacturers as well, and including major multinationals. So we work closely with the international partners in terms of cosmetics to supply technology and also the know-how to assist with new product development. The retail sector is well developed. We have a related infrastructure to distribute and supply consumer formulated products. We also have a well-developed marketing channel, which includes direct sales to consumers. Our export markets, particularly to SADC, are also well developed. So our technical infrastructure for product testing requirements are also well established. So we can therefore export cosmetics products, which has then also seen an increase from 7.8 billion to 13 billion in 2022, which is a substantial amount of increase there in terms of exports. And our weaknesses are then relatively small local markets. So 0.3% of South Africa's GDP and employment and our employment is estimated around 24,000. So with the 0.3% of SA's GDP, this includes then the personal care and the cosmetics. We have old, small, high-cost manufacturing facilities compared to international benchmarks. We have limited availability of upstream raw materials. So we import quite a lot of raw materials or ingredients that goes into the manufacturing of cosmetics and home care products and so on. So it's imported at a relatively high cost, and about 90% of our raw materials are imported. So raw materials imported were around 5.8 billion in 2015. It then increased to 9.8 billion in 2022. So we can see the correlation in terms of the exports that has increased, and we're also looking at, we needed more raw materials or more ingredients to manufacture these cosmetics. So our opportunities are then to replace these imports that are coming in, which is around 11.5 billion. The SADC EU trade agreement and AGOA agreement provides duty-free access. And in terms of 4IR technologies, we can provide improved manufacturing competitiveness as well as expand our customer services. Now, our threats, when we look at the threats that the cosmetic sectors face, also the cosmetic sector, we have a low economic growth in South Africa and in SADC. So the cost of feedstock impacts here. The currency fluctuations, we have lack of feedstock, we have to import more. When I say feedstock, is the ingredients or the raw materials. So we only have limited feedstock capacity in areas such as surfactants, solvents, and also in other ingredients. We lack manufacturing investment to maintain competitiveness. And lastly, we have an insecure and erratic electricity supply, which is now also placing severe strain on our companies, and it adds risks for potential expansion or where companies want to invest further. And also the future water security potentially also places a huge risk our companies. So in terms of the animal bill, we do see then that the impact will be significant, and that we have to look at our sector. When we say we're going to increase our production capacity, this will then result in more exports, and it will also then result in more product being imported. So we are in a situation where we have to look at the animal bill, because whilst the DTI might support the ban on testing of cosmetics on animals by manufacturing in South Africa, the country does not have control over legislation in other countries. So a ban only on South African manufacturers could prove to be unfair, and it can also jeopardize our growing domestic industry. So we then saying that an impact assessment study needs to be done on the impact that such a ban will have on the cosmetics sector of South Africa. This needs to be done, and it needs to be done over an extended period, probably over a year or so. And the ban should not be retrospective for cosmetic products. The ban should be in line with the Department of Health's cosmetic regulations. I think I'm going to hand over here to was our next slide, Elizabeth, if you can move to the next slide on the comments for the animal protection bill. I want to hand over to our colleague from the trade to talk a bit about the trade and the barriers of the effect of international trade on such as the WTO and technical barriers to trade agreements, which is international agreements. So I will then hand over to Elizabeth to talk a bit more on the trade side. Thank you. Thanks, Elizabeth. Thank you, Chair.
Mama Elizabeth, please proceed.
Sure, it seems DTI and technology don't work together well.
Thanks for your comments, Ntate Masipa. Mama Elizabeth, please proceed. Mama Elizabeth, please proceed.
Chair, I would propose that I'll read through the slides because they are here, just to assist my colleague Elizabeth. And then when it comes to the challenges or the Q&A, then perhaps that time Elizabeth will be back. Is that in order, Chair?
Yes, please proceed, Mamustein.
Okay, so the comment on the Animal Protection Bill, the proposed bill therefore seeks to amend the Animals Protection Act of 1962 to provide for a new offense related to the testing of a cosmetic or part of an ingredient of a cosmetic on an animal in the Republic, and to provide for matters connected therewith. So the objective of the proposed bill is to criminalize the testing of cosmetic on animals and to prohibit the sale and manufacturing of cosmetics tested on animals. So should these objectives have an effect on international trade, which they would, then the provisions of the World Trade Organization, WTO, or the Technical Barriers to Trade, known as the TBT agreement, is applicable. Next slide, please. The WTO TBT agreement encourages the development and adherence to international standards and conformity assessment systems. So the World Organization for Animal Health, the WOAH, or its abbreviation OIE, for further purposes, serves to promote global improvements in animal health and welfare and veterinary public health. The International Organizations for Standards, which is the ISO standard, ISO 10993-2/2022, which is the biological evaluation of medical devices, Part 2, animal welfare requirements. So this specifies that the minimum requirements to be satisfied to ensure and demonstrate that proper provision has been made for the welfare of animals used in animal tests to assess the biocompatibility of materials used in medical devices. So this is just the definitions. And then ongoing discussions, future reductions in the overall number of animals. I've just lost that bottom bit, okay, of animals. Use refinement of test methods to reduce or eliminate pain or distress in animals. Thank you. Thank you. Next slide, Elizabeth. International cooperation on cosmetic regulations, the ICRCR. So the Voluntary International Group of Cosmetic Regulatory Authorities, Brazil, Canada, Chinese Taipei, the European Union, Israel, Japan, Republic of Korea, and the United States. So they meet annually. Discussions are held on cosmetic safety and regulation, including alternative methods on animal testing. So please note, this input does not attempt to pronounce on measures that can be taken by members to protect animals and the impact of such measures. Next slide, please. So the TBT agreement further recognizes that no country should be prevented from adopting or enforcing measures to ensure the quality of its exports, or for the protection of human, animal, or plant life or health, of the environment, or for the prevention of deceptive practices at the levels it considers appropriate. So this is subject to the requirement that they are not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, or a disguised restriction on international trade. So consider, what is the object of the bill? Does it affect international trade? So we need to look at these options or the objects of the bill. Criminalize the testing of cosmetic on animals, prohibit the sale and manufacturing of cosmetic tested on animals. So the pertinent question is whether the measures are more trade restrictive than necessary to fulfill a legitimate objective. Now, the further considerations are that the TBT agreement grants the right to protect. However, there is a provision that a member should regulate for the protection of human health or safety, animal or plant life or health, or the environment of a partner country, unless there is a provision in an international agreement to which both countries, such as SA and the exporting country, are members. So a member preparing, adopting, or applying a technical regulation which may have a significant effect on trade of other members shall, upon the request of another member, explain the justification for that technical regulation. However, if the regulation or standard is in accordance with a relevant international standard, it shall be presumed not to create an unnecessary obstacle to international trade. Now, if South Africa imposes a prohibition on cosmetic products tested on animals against the originating country, such that trade, for example, imports of cosmetic ingredients, are affected, the measure or the prohibition will be evaluated by the WTO members or the World Trade Organization members on the basis of the provisions of the Technical Barriers to Trade or the TBT agreement. So the processes and procedures for adopting a measure will have to be adhered to, including allowing time for WTO members to comment on such a measure. The proposed addition to the bill on page 4 of the schedule further states that the provision shall not apply to an ingredient that may be included in a cosmetic, but which was tested on an animal for a purpose that was not related to the use of that ingredient in a cosmetic. So if this is clearly understood, meaning the prohibition, which could be considered as a technical regulation or a measure. So this means that a product tested on an animal but not intended as an ingredient for cosmetics will not be subject to the prohibition. So this brings uncertainty as to the real objective stated as animal welfare if it only applies to cosmetics. South Africa should consider carefully the meaning of this addition as it relates to the objective of protection of animals, irrespective of the final product. So this might raise questions on the real objective of the measure as it relates to international trade in cosmetics, inverted commas. So in conclusion, the concluding remarks are that the prohibition on international trade of cosmetics tested on animals has a potential to bring conflict under the WTO law, since it is not covered entirely by the WTO rules and may be subject to different interpretations. The overall objective of the WTO is to promote international trade and unjustified discrimination between trading partners, while the broader aspect, the OIE and the ISO might be to promote global improvements in animal, their welfare and veterinary public health. So for example, when the OIE sets intergovernmental standard that deals with animal welfare, or when such animals are traded and works to strengthen the members to implement them. Next slide, please. So we have another page on concluding remarks. So there is a lack of WTO case law that could bring light to the applicability and to the consistency of the WTO animal welfare provisions. And through the OIE and ISO standards, though the OIE and the ISO standards are recognized, reference for trading countries, the WTO established disciplines are upheld in that technical regulation should not result in unjustifiably arbitrary or unnecessary discrimination and should not constitute a disguised restriction on international trade. So the WTO cases are ongoing and have included analyses of the measure, which is technical regulation, standard, conformity assessment procedure, discriminatory effect, trade restrictiveness, considering the end use of the product, which is very important. Consultations with other countries that have instituted such a prohibition would be beneficial in order to ascertain what the implications are on trade and the specific trade concerns. Thank you, Chair. Thanks, Elizabeth. I'm not sure if Elizabeth is online. Yeah.
Thank
Yes,
you, honorable members. That is the presentation from DTIC, as well as from the Department of Health. We will now open the session for questions of clarity on how these two departments are impacted by the Animal Protections Amendment Bill. Honorable members, any questions of clarity or comments? Honorable Klape.
Thank you, Chair. Good morning to your good self. Good morning to my colleagues, the minister, and everybody on the platform. Chair, I don't have questions to these two departments. I followed the presentations. For an example, Department of Health, in fact, amplified the presentation from our department. And their comment is that they would support either whether there's amendments to the bill for the Principal Act or the regulations. So I think even with the second department, DTIC, I don't get any substantive thing that would say they are for or not. The fact that is coming out of this is that worldwide, there has not been a, what would you call it, a complete ban on the testing of cosmetic on animals. There's always remedial action in terms of countries' ability or permission to do regulation. So I'm good. Thanks, Chair.
Thank you, Honorable Klape. The Honorable Ntate Masipa, can we remove the presentation of DTIC? Honorable Masipa, you may proceed.
Good morning, Chair, and good morning, colleagues. Good morning, Minister and Deputy Ministers that are present and the officials from various departments. Chair, I just want to make some few comments. As you know, as the presentations are being made, one feels a bit, concerned as to how we're going to really tackle this. So far, Chair, we have, in terms of the public submission, 1,311 supported this particular bill that is before us, with, I think, about 7 objections. The petitions or the submissions from DRSA, which reached about 5,110 that supported the bill. So as far as the bill is concerned, the bill obviously recognizes the pain that is caused by this process of, testing the products on animals, which we acknowledge that this is a problem. However, there is some international trade issues that obviously are coming to the fore. I think for me, really, the question is, how long would it take for us to really do an engagement with international countries that are already, have already banned this particular treatment of animal in terms of testing cosmetics. But one really do acknowledge that there's obviously, an issue of trade imbalances, because I don't think the bill really suggests that by any means that once we have really put a ban on testing animal products and so forth, that it says that other countries must also comply to the South African law. And it goes back to my real question, the previous one, Chair, with regards to the animal welfare bill, that, this piecemeal approach, shouldn't we have just really considered looking at the animal welfare as a departure of addressing this particular challenge? Because really, Chair, I mean, it's acknowledged by both the Department of Health and the Department of Trade and Industry that the pain on the animal in terms of doing this is quite severe. However, the issue is the technical barriers of world trade, that might, affect us. But I think worldwide, there is kind of an acknowledgement that, from what you call the World Animal Health, OIE, that we got to really take care that we promote the welfare of the animals and ensure that we don't really affect them adversely. But I think the question for me, Chair, is that how quick can we really address, one, the issue of, while we don't have the case law regarding this, the issue of understanding how other countries have been able to do this without really impacting the technical barriers of trade. That's one. And the second, obviously, is going to be, I don't think that we have been addressed really properly, even in the past presentation. I think myself and Tape asked the issue of the trade imbalances. What is the kind of level of the trade imbalances that will happen should we effect this bill? Thanks, Chair. That's really my input for now.
Thank you, Honorable Dr. Masipa. The Honorable Memasho. Memasho. The Honorable Dr. Matiasa.
Well, thank you so much, Honorable Chair, for the opportunity to make some few remarks. Well, Honorable Chair, animal welfare and animal health protection is an important intervention in ensuring that animals, as both our natural resource and heritage, are protected and preserved against human decisions, actions, and behavior. Just as the environment, the planet have to be protected against those, animals also have to be protected against those. So this bill is intended to achieve exactly that, so that we keep we keep our environment safe, and safe not only to benefit human beings, but also to benefit animals. So whatever tests or medical measures which may be designed to be tested on animals should be of such quality that do not harm or endanger our animal species. So we welcome the presentations, and we also welcome the initiator of this bill, so that it serves as part of our national legislation for current and future generations. My only concern is that this is a technical piece of legislation which would have required that it should be taken to a wider audience of people for participation, not just to tick boxes for the legislatures, but to empower people and to enlighten our people to the need of taking care of animal welfare. Because from where I come from, I repeat what I said when this bill was presented first time. I have no conception or comprehension of animal pain. I'm a farm boy. When I see a rabbit, I see food. When I see a bird, I see something that I can eat. So such practices can only come to an end when people are enlightened about animal welfare and make them realize animals also feel pain when they are exposed to pain. That will all what I can say, Honorable Chair, for this morning. And greeting once more, Dalibong. Thank you so much.
Hey, Ntate Mfokeng, the farm boys want to eat everything, huh? Good morning. Honorable Kapa. Ntate Kapa. The Honorable Mamun Babama.
Thank you, Chair. I am covered by my colleagues. Thank you.
Nkosi Mpondomse. Bude bamilisekisa bukumkani bamaMpondomse. Siyabulela. Honorable Mahlo. Agbare Breed.
Dankie, Voorsitter. I was just beginning to think that you have forgotten about me. Chairperson, maybe I want to, well, let's start by thanking the presenters and the departments for the presentations. I just have a few comments and then a few questions. My first comment would be to the Department of Health. And I've noticed that they've also made mention of the fact that there's currently no technology and expertise in South Africa for alternative methods of testing of cosmetics. And I maybe just want to leave it at that and say, but testing currently does not take place on animals in South Africa or for cosmetic purposes. So I don't completely see how that is relevant to this argument whatsoever. But then to move on to DTI, Chairperson, they have made mention that they've said the prohibition on international trade of cosmetic tested on animals has a potential to bring conflict under WTO law, since it is not covered entirely by WTO rules and may be subject to different interpretations. I just want to get clarity on that, because how will this impact the WTO if there will be no change in the status quo? If they can just speak to that. Then also I would like to know, how will it impact if how will it impact South Africa and these trading options if there currently doesn't the testing of cosmetics on animals is currently not taking place in SA, and then how will it impact imports? They've made mention of that because currently this bill does not speak of imports, it only speaks of the regulation within South Africa. I would just like clarity on that, Chairperson. And then, Chairperson, maybe just I would like to acknowledge, and I would thank the presenters specifically for making note of the impact that it has on animals and how the testing actually causes suffering in animals, and that both these departments also made mention of the fact that it is internationally, other countries have led the way in actually banning cosmetics, testing of cosmetics on animals, and that I think that South Africa would be one of the leaders. And I think I made the point in a previous committee meeting where I said if even India, which is, in my opinion, a country that has worse problems than South Africa, can actually have legislation banning the testing on animals, I say South Africa should really consider that, Chairperson. But that is just my comments, and then my 3 questions to the Department of DTIC. Thank you.
Thank you, Akbar Breed. The Honorable Kapa. Dabezit, Nkosi enkulu.
Thank you, Chairperson. Once more, greetings to you, Chair, and all members and the Minister and the presenters who are presenting. I as well don't think I have any question or comment with regards to it.
Thank you, Ndabezit.
Honorable Chair, here's Tapa.
You may proceed, Honorable Kapa.
I'm sorry, Chair. Pardon me. The problems with the technology. I greet everybody on the platform and thank you very much for the presentations, Chair. I don't have any clarity except there's only one thing that I want to understand. Because I do suspect that many people have had their inputs and their suggestions on the bill, on the proposed bill, before having this input from these 2 departments. Now, I would like to understand whether they will still have and these other 2 departments, and be sure that they would still remain on the positions they are at the moment, because I think it is important that this information from these 3 departments are arming anybody who's making a decision on the bill. I thank you, Chair.
Thank you, Honorable Kapa. The Honorable Kruger.
Thank you, Chair, and thank you for the presentation, and greetings to everybody, Minister, Deputy Minister, colleagues. Chair, yes, I'm sort of covered by my colleagues. However, I think it's very important for the impact assessment to be done, because this can have a huge impact on the ease of doing business for many, especially small traders and small businesses. So I just want to make 100%, and it was mentioned by one of the presenters that impact assessment should be done. But I also want to add that in this impact assessment, the ease of doing business must be included. Thank you, Chair.
Thank you, Honorable Kruger. The Honorable Tate Muntwedi.
Microphone.
Honorable Kapa, please mute your microphone. The Honorable Tate Muntwedi. Honorable Swart.
Chairperson, good morning to you and good morning to my colleagues. Good morning to the departmental officials, the minister if she's still here. May I first thank you, Chairperson, and colleagues for the amount of time and attention that you've given to this bill, this very narrow bill, and remind us of our words that we said right at the beginning, Chair, when you said this is a very progressive bill. Chair, I would just ask you for a few minutes, as other members have commented. There seems to be a misunderstanding about the impact of this bill. It is so narrow, Chair, and it is preemptive. There is no testing at the moment of cosmetics on animals in South Africa. There are already 7,000 proven safe ingredients worldwide, but there is, as my memorandum points out, there is an international trend towards banning cosmetic testing on animals, and it is very widespread. Even BRICS countries such as India, China are adopting these methods. Chairperson, it does not impact at all on any imports or exports. So I don't understand the DTI's presentation at all. There's no impact because we have the status quo at the moment. There are no laboratories in South Africa. Chairperson, I really appreciate the Department of Health's approach. I think that they have come with very constructive, in as much as they've said they've got no objection, bearing in mind that one of the aspects of the amendment relates to the bill which falls under the foodstuffs cosmetics. They say either the amendment or the regulation. The Department of Agriculture, Chair, had a lot to say that there's no, for example, no technology or expertise in South Africa for alternative methods. That's because there's no laboratories in South Africa. It doesn't happen in South Africa. It doesn't impact at all in South Africa. And that is the point I want to make. I really appreciate the Honorable Matias's comments, other members' comments, just in as much as, and I think the Honorable Kapa also mentioned that would the public view this differently if they heard these presentations? And that's why it might be important, Chair, to refer this for public comments again, given the narrow nature, the very narrow nature of the bill. It is so narrow, Chair. It is preemptive there, and it is following other countries such as New Zealand, which also does not have any laboratory testing, but they're saying, should anyone apply, then, Chairperson, that act will apply. Chairperson, I would like to just understand from DTI. They make certain comments, and this is direct questions to them, because I think, and I appreciate, Chair, that this is a very technical bill. But, Chairperson, it says, for example, on page 12, the prohibition on international trade of cosmetics tested on animals has a potential to bring conflict under WTO law. That is not what the bill says. We are not prohibiting international trade of cosmetics. We are only seeking to ban cosmetic testing in South Africa, and it doesn't impact at all on any impacts. It only restricts manufacture of sale of cosmetics tested on animals in South Africa. There's not a question about that relating to WTO. So I do not understand that. I think that it's misconceived from DTI's perspective. Chairperson, also there's a slide here that I want to clarify. That I want clarification from the department, if you permit, DTI. But again, on slide 10, if South Africa imposes a prohibition on cosmetic products tested on animals against the originating country, that's against another country. That is not what the bill says, Chair. It only speaks to South Africa. There's no question about that. So that falls away. The arguments of DTI fall away totally, and in fact brings us into line with the international trend of banning cosmetics on animals. Chairperson, the issue about small businesses, it's not impacted because the status quo applies. There is no cosmetic testing on animals in South Africa. It's not going to affect anyone in any way. And if people want to look, as I said, there are 7,000 proven ingredients already available in South Africa. It doesn't impact. There's an exemption about medical testing, doesn't impact that at all. And the one little clause that says, even if even if a person tests for medicines and they find that it can be used for cosmetics, there's a legal term. I'm giving you legal input as a lawyer that you cannot use that then to say this is a loophole. In France legis, that would be fraudulent to then use that. So, Chair, I would plead with the honourable members to let's bear in mind, as I set out in my memorandum, Chair, the impact that this has on animals worldwide. You, Chair, indicated more than 100 million animals are tested worldwide. That is why countries are moving away from that. Chairperson, just I appreciate you've given me a minute or two, but I want to just conclude by saying the Constitutional Court has said we need to protect animals and we need to understand what is being done here. It is animal tests, rubbing substances on shaved backs, dripping substances into their eyes, painting substances into their ears, forced inhalation of substances and forced feeding of levels that cause illness or death. If these animals do not die during this testing, they are subsequently killed. That is why the alternative testing, but we don't even consider that. We are preemptively looking at something that should it happen in South Africa. I would plead with you, Chairperson, and I appreciate.
Thank you, Honorable Kruger. Honorable Swart.
Yes, Chair. I just wanted to conclude with one sentence to say, if at the end of the day, the committee decides this is not desirable for whatever reason, I would urge the committee in a report to then fall back on what the department recommends, and that is regulations to stop should this even happen. And maybe the committee would consider that in its report as a fallback position. So at least all the organizations and the thousands of people that are watching this would have something to say after years and years of effort. Thank you, Chairperson, for indulging me for a few minutes. You'll hear I'm very passionate about this issue. I appreciate your time. Thank you, Chair.
Thank you, Honorable Swart. Honorable members, are there any honorable members on the platform that I have not recognized who may wish to pose a question of clarity or comment? Thank you, honorable members. Allow me to invite the Department of Health and also Department of Trade, Industry and Competition for responses. Department of Health.
Thank you, Chairperson. Yeah, after considering the intent discussions and very valuable insights from the other stakeholders, we maintain our stance regarding the initial stance that we made. That is, this issue lies mainly with the Principal Act, and also the impact is as the Department of Trade, Industry and Competition has indicated. So the Department of Health position on this is that we would implement the act as it is, or if there are regulations that are made, or if there are amendments that are made, it is the environmental health officials in the Department of Health, as well as the municipalities, that would serve the role as enforcement of the legislation. So we will continue with that activity or responsibility. Thank you, Chairperson.
Thank you, Dr. Wayne. Any other further responses from Department of Health? If not, we'll move on to DTIC.
Thank you, Honorable Chair. Let me apologize again for frustrating yourself and your meeting earlier. I will make some general comments. Firstly, I should state that the DTIC doesn't take a position on whether testing on animals is good or bad, whether we should have it or not. Our input is merely to alert the committee to the WTO TBT agreement, Technical Barriers to Trade, and that it might have a bearing. Now, trade is not necessarily only imports. It is also exports. We've seen that we have a vibrant little cosmetics industry, and it might happen in future that they should be in a position to export to a significant degree. And of course, that whatever domestic regulations we then have that impact on the manufacturing would also impact on the ability to export. So taking from that, I want to put an emphasis on what is in slide 8, where it says that countries could have such regulations, but it's subject to a requirement that regulations must be applied in a way that would not constitute an arbitrary or unjustifiable discrimination between countries, and also that measures should not be a disguised restriction on international trade. So that is a general rule that often applies in trade, not arbitrary, not unjustifiable, not a disguised restriction to trade. The issue of this being prohibiting testing on animals for cosmetics, but if the testing is done for a different purpose, then it is not prohibited. That could create a bit of a trap, because the question now arises, if it is wrong to test on animals for cosmetics, why is it not also wrong to test on them for a different purpose? And it is something that could be constitute a grounds for a I don't want to use the word as formal as a dispute, but certainly it would raise questions. The point is, when we implement such a prohibition, a ban, a measure, it might be relevant to notify it in the WTO TBT committee for other members to be aware of it and to have a reasonable period of time to comment if they should find a problem with it. In all likelihood, for the explanations given by various of your members, many countries are already moving against testing in animals, so it might not elicit much of a discussion, but it might nevertheless be necessary to take note of what would be the correct procedure should this go ahead. Chair, I say again that we don't take a position on whether this is good or bad. We only want to give your committee an understanding of what might be the international agreements that might have a bearing here. Thank you, Honourable Chair.
Thank you, Mamu Elizabeth. Any further input or responses from the DTIC? Mamu Stein. I see a hand from...
Chair, allow me, my
Yes.
colleague, Ms. Sina Mosekla, which is the Director of Chemicals and Cosmetics at the DTIC. I see her hand is up. Thank you.
Thank you, Memo Setla.
Thank you, Chair, and good morning, everyone. All protocol observed. Chair, I'm based within the sector desk for the cosmetics sector at Department of Trade, Industry and Competition, and I'd like to answer a few questions that were raised on the platform. As far as I know, in the cosmetics sector in South Africa, we do not test cosmetic products on animals, Chair. I'm even surprised that we even want to ban something that we are currently not even implementing in the country. That's number one. Number two, Chair, many cosmetic manufacturers in South Africa also manufacture home care products in their facilities. And as Ms. Claudine mentioned in her presentation, 90% of raw materials that we use in the cosmetic sector, home care sector, are imported. We do not have the capacity to manufacture majority of the ingredients that we use in the cosmetic sector. And we import ingredients from all over the world, from around the globe, from even countries that have not yet banned testing on animals. And I'm not saying that testing on animals, it's a good thing to do. Of course, our animals, we love them as well at the DTIC. But how are we going to restrict now the 90% ingredients that we are importing that we need to make our cosmetic sector here? Are we also going to ban them? Also, Chair, to note that we are a free trading country. We import finished products, we export finished products. Are we also going to ban cosmetic products that we bring into the country that are tested on animals in the countries of origin, Chair? So those are the only questions that we were putting to members, that we use a lot of ingredients that are based within the chemical sector, not even the cosmetics, that are tested on animals. So this ban, we need to make an awareness as well to the manufacturers out there in all sectors that please now look for alternative products that you can use to replace the ingredients that you used to use. Hence, we are saying that please, let's do an impact assessment to check how this will impact the chemical sector at large, not only the cosmetic sector. And also, if we love our animals that much, why are we only focusing on cosmetics, not all other sectors like food, medicinal, chemical sector? If we want to ban testing on animals, let it be for all sectors. It shouldn't just be on cosmetics, because we are not even doing it for cosmetics in South Africa. Thank you, Chair.
Thank you, Ma'am Mosehla. Any further input from DTIC?
I'll just add, Chair, that in relation to whether the bill has any implications for trade or any legislation to trade, the policies and South Africa's commitments in these international agreements, it is then the view that our view that it's likely that our adherence to the terms of technical barriers to trade of the WTO that may result in South Africa being unable to impose the measures on imported cosmetics or cosmetic ingredients. And as Ms. Mosehla had said, Sima, as she has said, we import a vast number of cosmetic ingredients. We are mainly an importer because we don't manufacture feedstock and so on. So this is where the challenge lies, and that impact assessment study that is being proposed that will be very useful going forward. Thank you.
Thank you, Ma'am Mustaine. Ma'am Mosehla, your hand is still up. Please lower your hand if it's an old hand.
Apologies, Chair. It's a new hand. It's a point that I forgot to also mention, that currently the cosmetic sector, we have a regulation that has been developed by the Department of Health, and that regulation has not been enforced since 2017. Industry has been asking, why are we not enforcing the regulations, asking government, and Department of Health's response is that they do not have human resource capacity. So if we are now bringing in new legislation in the cosmetic sector, when we can't even currently regulate the sector as it is now, will they have capacity to enforce this particular change? Thank you, Chair.
Thank you, Mama Mosehla. I see the end of Honorable Ntate Masipa.
Thank you, Chair. Chair, I just want to do a follow-up question to DTIC. The question really is, which countries are currently using animal to test their products? And of those countries, which are those that we are importing our cosmetics from? If they have got that information, they're welcome to share with us now, or if they don't have, if they can really provide in writing, share. I'll appreciate. Thank you.
Thank you. Akbare Breed.
Thank you, Chairperson. Maybe just a last one, also to DTIC, is where is the ban on the import of ingredients? If she can just clarify that, please.
Thank you, Akbare Breed. Please lower your hand with Honorable Masipa. Any follow-up questions, honorable members? Ntate Swart.
Chairperson, thank you so much. And I really appreciate the DTI's input. I just want to emphasize and ask them again, where in the bill does it relate to anything about imported ingredients that have been tested? It does not refer to any of those issues, does not impact that at all. So I don't understand the issue of the 90% ingredients that are being imported. This will not impact that at all. Thank you, Chair.
Thank you, Ntate Swart. Lower your hand, please. DTIC.
So, Chair, in response to all the questions that are being asked, can we provide written feedback in terms of the questions that were posed now, in terms of the countries that are we importing from? Because it's the majority from China and from the European Union and so on, but to give more specifics. And also in terms of what the other colleagues have raised on the meeting, if we can provide in terms of the trade-related issues as well, to provide feedback to those questions that were posed today. Thanks.
Thank you, Mamustein. That was the request from Honorable Tate Masipa, so we will appreciate if you can send us the information in writing. Any further responses from DTIC on the other questions raised? Mamu Elizabeth.
Thank you, Honorable Chair. I join my colleague Claudie. We will also assist in providing the written responses where it's relevant. I would also like to say that my colleague Tembi Mangeni, who I introduced in the beginning, has in the meantime been able to join us. She's the expert on the TBT agreement, so she will also assist with that. And with your permission, if she has something to add at this stage, apart from what we will provide in writing after the meeting, then that could also, I trust, be helpful to yourself at your meeting. Thank you, Chair.
Thank you, honorable members. That is the responses from the Department of Trade, Industry and Competition, DTIC, as well as the responses from the Department of Health. With the presentations that have been put before the committee by both departments, as well as the Department of Agriculture, Land Reform and Rural Development, honorable members, we therefore need to decide as a committee whether, in your opinion, if these presentations that have been brought before the committee bring us to the conclusion of moving for the motion of desirability or rejecting it. I will request the Secretariat to explain in brief what the process is in terms of motion of desirability, so that we can look into that before we proceed to voting accordingly. Manyamza, Mamukakaza. Akbar Brett, I see your hand.
Thank you, Chairperson. Maybe just a question of clarity. DTIC still needs to provide us with those answers of the Honourable Masipa's question. Would that then not refer the voting on the motion of desirability, or do we proceed even if we don't have that information in front of us? Thanks.
That information, Honourable Brett, is not truly having an impact on the bill. It is information that Honorable Ntate Masipa would want us to have as a committee in terms of what comes into South Africa from the different countries. So the Department of Trade, Industry and Competition will supply us with that information should we want to engage with those things that are brought into the country. But for the purpose of the bill, we need to proceed in terms of if the motion is desirable or not. And this is why I would like the Secretariat to explain the process. Manyamza, Mamkakaza.
Thank you very much, Chair. Chair, according to the rules, Rule 2864, the rule says after due deliberation, the committee must consider a motion of desirable on the subject matter of the bill, and if rejected, must immediately table the bill and its report on the bill to the National Assembly. If the motion of desirable is adopted, the committee must proceed to deliberate on the details of the legislation. That's what the rules say, Chair. So that is if the committee decides to reject this bill, that means immediately the committee must table the report on the bill to the National Assembly, and the report must explain the reason for the rejection. And also, if the motion is adopted, therefore the committee must proceed and deliberate on the details of the bill, of the legislation. Thank you, Chair.
Thank you, Mamukakaza. Mahadebe, any further input?
She is not available, Chair. She has gone out to Home Affairs.
Thank you, Mamukakaza. Honorable members, that is the process before the committee. I would therefore like to put it to the committee in terms of motion of desirability to ascertain if the bill is desirable or not desirable, so that we can be able to come to the understanding if we proceed to process it or if we reject it and table a report to submit to the National Assembly. I therefore would like to ask the committee for those that move for the desirability of the bill. Can we have show of hands? I think it will be easier to count the hands on the screen.
Sorry, Chair, we are now voting for the motion.
Yes, we are now voting. This is why I've requested honorable members to raise their hands, because then it will be easier to see the hands and count the hands and give the number of hands on the screen to the members. So far, we have 2 hands voting in favor of the motion of desirability, Akbare Bread and Honorable Ntate Matias. The Honorable Ndabezitha Nkosi Cebekhulu, 3 hands, voting in favor for the motion of desirability. That is all honorable members. Any other hand?
Chair, on a order. Maybe I might just miss. Chair, shouldn't I think we will require a mandate from our caucus in terms of really deliberating going forward. Shouldn't we postpone the move before we present to our various caucus and deliberate on the bill?
Unfortunately, Tate Masipa, we are here as members of parliament representing our different caucuses, and you as a representative representing your caucus hold the mandate. So you can either abstain or vote in favor or reject. Then you will be able to speak to the bill in the House when it arises. But we are all here having a real mandate to do the work that Parliament requires us to do. So on the motion of desirability, I do have 3 hands with the hand of Honorable Cebekhulu Ndabezitha. I think he might have just been kicked out, as I don't see his hand anymore. But we did count 3 hands standing for motion of desirability. Can we see hands, honorable members, for the rejection of the motion of desirability, so that we can gain clarity?
Honorable Chair, perhaps.
Ntate Matias.
Look, members should not confuse those who are hesitant to raise their hands, should not confuse the motion you are calling for, motion of the desirability, as a motion of endorsement. That's the first point. Second point, I find it strange that members spoke so positively in favor of this bill and yet hesitant to raise their hands. Is that an indication of what is called what do they call it?
Dr. Matias, I don't want us to probe other members.
Okay, let me leave it there, Honorable. Yes, let me leave it there.
In voting, we allow members to vote as to what their desire is, and also what the mandate they've been afforded. So we do have 3 hands voting in favor of desirability of the bill. Now, I've requested you to lower your hands so that we can see the hands that are voting in rejecting the motion of desirability. Can we have the hands that are voting to reject the motion of desirability?
Chairperson.
Honorable Traitor.
Chair.
Yes, Honorable Traitor.
Sorry, Chairperson, my gadget does not, oh, I found it. I wanted to register I'm voting against, but I could not find in this gadget that I'm using the option to raise a hand.
Thank you, Honorable Traitor. We've registered your vote verbally or vocally, as well as on raised hand. Honorable members, any other members voting in rejecting the motion of desirability?
My hand is up, Chairperson.
I see the hand of Honorable Member Shaw. We have honorable members, 4 hands voting against the motion of desirability, therefore rejecting the bill. Any further hands, honorable members? For the purpose of recording this, 4 members of the committee have rejected the motion of desirability and rejected the Animal Protection Amendment Bill. And we have 3 members of the committee that have decided to vote in favor of the motion of desirability. And therefore, honorable members, we will only be left with compiling a report that will be sent to the National Assembly in highlighting the deliberations that we had on the bill, and that will conclude, therefore, the process that we have had in terms of dealing with the bill. And the further decisions will be undertaken in the National Assembly as to what is Parliament going to do further. That will be all on the presentation. Can I request members to lower their hands so that
Chair?
I can be able to recognize the hands that are coming up, having dealt with the procedure and the voting? We have the 3 hands, which I see, of Honorable Breed, Honorable Swart, and Honorable Masipa. You may proceed, Akbar Breed.
Thank you, Chairperson. No, just on a point of clarity, Chairperson, there are members that are present in this meeting that have not cast their vote yet. So I believe it would be in order to ask for abstentions just to ensure that we have the procedure is correctly done.
Correct, Akbar Breed. I was also gonna note the other members on the platform that didn't vote as people that have abstained. But if you want me to put the question, I will proceed to do so. Honorable Swart.
Chairperson, I just wanted to thank you and the committee, and in particularly those that supported the desirability of the bill. I do appreciate the amount of time that the committee has given to this matter. Obviously, I'm disappointed at the outcome, but I wanted to express my appreciation to you and all members of the committee. Thank you so much.
Thank you, Honorable Swart. Honorable Ntate Masipa.
Chair, thank you very much. I just wanted you to record our abstain from voting positively or negatively. I think the point is that we are making is that we don't feel that enough studies or work has been presented to this committee to make a proper decision around, whether to vote for proceeding or to vote against the desirability of the bill. Thanks, Chair.
Thank you, Ntate Masipa, for highlighting that you abstain. I therefore would want to put the question fully and see the hands so that we record it for the purposes of the meeting, honorable members. Can all the members that are abstaining from the motion of desirability raise their hands? I see the hand of Honorable Masipa, the Honorable Mamumbabama, two hands from the honorable members of the committee who are abstaining. Is that all? Thank you, honorable members. I will record it that two members of the committee abstained from the motion of desirability. Thank you, honorable members. The Animal Protections Amendment Bill report will be compiled by the Secretariat and the content advisors and our researchers and brought before the committee so that we can adopt it and send it to the National Assembly. Allow me, therefore, honorable members, to invite the Honorable Minister Umama Utogo Didiza of the Department of Agriculture, Land Reform and Rural Development to proceed with the presentation that we had on the Ministerial Task Team that was dealing with the Ingonyama Trust. The presentation, honorable members, was put before the committee, and therefore we were able in that regard to request for members to interact with the document. I will hand over to the Honorable Minister for opening remarks, and then allow honorable members to engage with the presentation that was put before the committee in terms of questions of clarity or comments. I see, Honorable Minister, before I hand over to you, the hands of Honorable Masipa and Honorable Mbabama are still up. Can I therefore ascertain Honorable Masipa and Honorable Mbabama? Why are your hands up? Honorable Masipa's hand.
It's legacy. It was a legacy.
Okay,
hand.
it's a legacy hand. Thank you for clarifying that. Mamumbabama, your hand is still up. Is it a legacy hand?
No, Chair, it's a new hand.
Yes,
I was
Mama.
just requesting. That we are reminded of the why why we actually requested the minister to make this presentation. Oh, what was the brief? Those are the words that I wanted to ask, Chair, please. If we can be reminded of the brief from the committee. Thank you.
Thank you, Honorable Mbabama. This was a request from the committee that we request the Honorable Minister to come before the committee and present the mandate of the Ministerial Task Team in how they came to be and what their work was in terms of dealing with Ingonyama Trust and what their findings were. So we therefore requested the Honorable Minister to come before the committee to give us an update on that so that we can close on this matter. Mahmoud Didiza.
Thank you very much, Chairperson, and thanks for giving the context as to why we had to come back to the committee. as indicated in the presentation that we've made, we've clarified why the president had set up that ministerial task team. As we had indicated in our presentation, that in 2018, there was a high-level panel report that came out, headed by the then President Motlanthe, which was actually commissioned by the Speakers Forum, headed by the Speaker of Parliament then. The aim of that panel was to look at legislation following from 1994 to 2018, what the impact of that legislation has been to our society. So arising out of the work that the Commission did and its recommendation, when they dealt extensively on legislation that deals with land-related matters in South Africa, they made their observation about the pace of land reform, the challenges that land reform was facing in its implementation, and one of the issues that they raised in respect to tenure reform related to the governance of land in communal areas and the role of traditional leaders. And you would recall that at the time, one of the issues that they raised, which I think caused a bit of a stir among traditional leaders, was the reference of tin pot despots, which angered a lot of traditional leaders about what that reference meant and how they were understanding of it. But also, they made observation about the duality where on one hand you have got communal land that is under customary tenure and in terms of its trusteeship is under the state, and you then have got Ingonyama Trust land, which in terms of Ingonyama Trust Act has a trustee, the King of Amazulu. So they raised those issues and many others, of course. But arising out of that, I think in the debate publicly, there were various views about whether or not there was agreement with the recommendations or the observation of the panel, which had led some of the contestations, particularly in the province of KZN, where there was a feeling amongst others that this will actually encroach to Ingonyama Trust or Ingonyama Trust being taken away from the trustee and all of those matters. The king then, late Inkosi Uzwelithini Kabhekuzulu, then requested a meeting with the president to discuss matters between the two of them, including Ingonyama Trust. You'll recall that in several articulations, the president was very clear that the state has not taken a position on taking away Ingonyama Trust land. However, the state is looking at how finally we deal with the issue of communal land in South Africa, which is under the trusteeship of the state. The Ministerial Task Team was then set up to prepare for the meeting of President and the then Isilo Samabandla. Because the Ingonyama Trust matters was part of the issues in the environment, therefore the committee touched on that matter. But as I said again in our presentation, the specific purpose of that task team was to prepare for a meeting. The way the task team was set up, the chairperson was the late Minister Mthembu Jackson. It was Minister of Culture, Minister Dlamini Zuma. It was Minister of Health, Minister Zweli Mkhize at the time. It was Minister of Water, Minister Mchunu. It was Minister Gungubele. Minister in the presidency then, it was Minister Togo Titiza, Minister of Land Affairs. And it also included Premier Sihle Zikalala, who's now the Minister of Public Works, and the officials who were supporting from these departments. In the meeting, then when looking at the preparation, the committee, in their view, felt that President has already articulated the position of government in respect to Ingonyama Trust. And there was a feeling that this matter shouldn't be used as a political matter. Rather, the issues of Ingonyama Trust, issues of its governance and its performance must be allowed to be dealt with by the line function minister, in whose purview that's where Ingonyama Trust Act falls. So that was the end of the Ministerial Task Team and how it dealt with that matter. Observations that the committee had made was to suggest to the minister and the MEC of COCTA in KZN and the Minister of Human Settlement in KZN that there are issues that Ingonyama Trust must deal with. And therefore, these ministers were, MECs rather, were highlighted because of one or other responsibility they had that impact on the Ingonyama Trust. As I indicated in the report, one of those was that under Ingonyama Trust land, you had townships which used to fall under KwaZulu government. And the view, and as you will see in the legislation, that those townships were supposed to go back to COCTA. So those were known as 239. That's how they were called. So that's what the task team said, that process must be concluded. The second one related to the management of the land, given that the delegation of managing some of the issues relating to communal land was actually delegated to the Minister of COCTA. That is why you will recall, honorable members, and we've said it in the presentation, when the litigation on the Ingonyama Trust came into place, the court actually said, though the delegation was given, it did not absolve the minister to ensure the protection of communities under Ingonyama Trust. So in respect of Ingonyama Trust, that task team ended there. They never proceeded with that matter because in their view, it had no bearing on the preparation of a meeting between the king and the president. So what I then did in the presentation last week was to then highlight what we did then as a department going forward in addressing these matters that we were asked to continue to deal with, not because the task team was going to expect a report from us in any way. In their view, the portfolio committee had its own responsibility in terms of the oversight of the department and how it executes its task. So they didn't see themselves as in any way expecting a report from us or in any way having a mandate to deal with the matters of Ingonyama Trust. So that's where the matters in the way in which we gave the presentation, Chair, but I just thought I needed to spend time to give the clarity. If one takes into consideration the responsibility of the ministry and department in respect of Ingonyama Trust, it's very clear that the minister must make sure that a board is appointed so that it assists the trustee in the management of Ingonyama Trust land. Secondly, the Act, therefore, in the way in it's structured, expects that the board will be responsible for the governance of the Ingonyama Trust and how the management of that land is undertaken. Obviously, where there are challenges in the way of the functionality of that board, the minister can intervene and assist the board to keep into its mandate. And it also provides for regulations that the minister can make to ensure that the smoothness of the running of Ingonyama Trust is undertaken. So those would be my opening remarks, Chair, to just clarify the issues from the MTT and what we then did as a department. I thank you, Chair.
Thank you, Honorable Minister Mamutoko Didiza of the Department of Agriculture, Land Reform and Rural Development. Honorable members, that is the input from the Honorable Minister, together with the presentation she brought before the committee and presented. We'll now open the session since the honorable members have had ample time to interact with the document and also receive the input from the Honorable Minister. Any questions of clarity in regards to the Ministerial Task Team that was dealing with Ingonyama Trust? Honorable Klape.
Thank you, Chair. These gadgets, I don't know if they're freezing or what. Chair,
Everyone is challenged by technology today.
I'm trying to unmute myself. It takes forever. Let me welcome the presentation, Chair, that we received and the brief that the Minister has just done. Chair, like we indicated, went through the presentation and what we requested as the committee. And I acknowledge that there's clarity on the role of the Inter-Ministerial Task Team then that was put together. And as this committee chair, we wanted the department to touch on issues of governance within the Ingonyama. And the minister is alluding to two issues. That one that dealt with townships and the land management. And the progress has been indicated as where it went and other initiatives that she took as the minister. I think, Chair, my comment will be, as this committee, we will be working together with the new board to deal probably or observe or even monitor the issue of the court on the PTO conventions, the appeals. We will be here also continuing to work with the new board on our concern in terms of the role of Ingonyama Holdings, so that as when we deal with the accountability of this entity, such matters don't fall into crack. But as for what we requested for this presentation that has been done, I think I'm okay, Chair. I know where it is and we know for sure how far as to the mandate that was given to that particular tax team. Thank you.
Thank you, Honorable Kape. The Honorable Ntate Masipa.
Chair, can you give Honorable Mbabama a chance? I'm just looking through my notes quickly. I think I did sponsor some questions.
Thank you, Honorable Mbabama.
Thank you very much, Chair, and thank you to the Minister for a very comprehensive background on the ministerial committee, the people who made up the ministerial committee, and what the ministerial committee has done thus far. Chair, I have a question that will probably lead to other questions depending on the answer. Now, I don't know if you will indulge me in this. I would like to know, out of the board members of the new board, how many have been reappointed to their positions out of the members that are there? The reason why I'm asking this question, Chair, is that my other questions will depend on this answer. So I don't know if you will indulge me, and we ask the Minister to also indulge me by answering this question, or whether you want me to carry on with my other questions, which should fall away depending on the answer.
Thank you, Honorable Mbabama. You should pose your questions, and those that you don't want to pose, you can keep as follow-up questions. And if we do still have time, we will take follow-up questions. But I would, yes.
Let me carry on then. So my first question to the Minister is, how many of the new board are members that have been reappointed to the board? I would like to know that. I see that we have 9 members. Of the 9 members, how many have been reappointed? And having said that, I would like to find out if there is a majority of members who are reappointed to the board, how does the Minister see them resolving the matters of the Ingonyama Trust and the board itself? How does she see them resolving matters going forward if there is a majority of people who have been reappointed? Because obviously they have failed in the past, and we would not like to see the same people. And the reason why I'm also asking this is that I see there is Advocate Linda Zama, the vice chairperson, and I feel that she has been a vice chairperson forever on this board. Unless I am mistaken, the Minister will correct me on that. And then also, Chair, the Minister starts off her presentation with quoting the Mutlante, the high-level panel assessment, whereby it was felt that the Ingonyama Trust board should actually be repealed. And the Minister says that this was not one of their considerations. I would like to know, why was it not part of their considerations? Considering that other Amakosi, or should I say kings, actually not even Amakosi, kings, are very disgruntled about the fact that the government is paying 24 million, 23 million every year to the Ingonyama Trust, when other Ingonyamas are not getting the same amount of, there is no consistency across the board. And I see that she also says that, and I will quote verbatim from the presentation: macro policy and legislative review. There is a macro policy and legislative review that would culminate in the promulgation of a law of general application that would improve security of tenure across the country. Now, when I read this, I was really happy, because I thought, okay, then it means that the Ingonyama Trust Board is being repealed, and there will be then in its place a macro policy and legislative review. that would be consistent across the board and look at you know, all the provinces the same way. So my next question, probably having said that to the minister, is what happened to this macro policy and legislative? Was there a legislative review that would culminate in the promulgation of a law of general application across that would improve security of tenure across the country? Is the department working on this, or has this been also put in the back bench, as it were? And when I also look at the recommendations, I'll call them recommendations of the Inter-Ministerial Committee of the people that the minister mentioned, all of them seem to throw the ball back at the new board, or supposedly new board. And I'm worried that does the board really have the powers to resolve these issues? And as I said before, Chair, all of these questions all go around whether or not, you know, the 9 people in the board, how many of them are new and how many of them are recycled, you know, the old people that were recycled. So there are quite a lot of things that this new board has to do: a clear policy on disbursements to communities, which is absolutely critical, because that is what people have been complaining about. And the committee as well has been complaining about the fact that the disbursements are not getting to the people they're supposed to get to. What is happening with the money? Where is the money? Transfer of R293 townships, that also has to be done by the new board. Completion of survey of IT land, also very critical. Is the new board going to be able to do this? What does the minister think in terms of the Surveyor General assisting? Has the Surveyor General got the capacity to do this? Ingonyama Holdings, we are so worried as a committee about the Ingonyama Holdings because there are accountability issues there. It is supposed to be the commercial wing of the trust. Is it a really necessary entity? And has the department and the minister really delved deeply into this to see whether this Ingonyama Holdings is a necessary entity going forward? So, Chair, I think all of my questions, as I said, start with whether there are any board members that have been recycled. And, you know, I'm really worried that we are working with the same people once again. Thank you, Chair. That will be all for me from now.
Thank you, Honorable Mbabama. The Honorable Memasho.
Chairperson, thank you very much for the opportunity. Yes, Chairperson, I think Honorable Hlape has indeed covered me on most of the issues that I wanted to raise, and I agree with her. Indeed, our work is to work with the board, the new board, and do oversight on the board, and also doing monitoring and evaluation on their work. Partly the implementation of those policies that are in place, and also review those that need to be reviewed, so that the implementation of a day-to-day activities can be able to run smoothly. As in the past, the Chairperson, you'll remember, we had issues with their policies which were not in place, and we requested them to review some of those policies so that definitely showed that their work can be the work that each one of us can be happy about. Thank you, Chair.
Thank you, Honorable Memasho. The Honorable Kruger.
Chairperson, I'm covered. Thank you.
Thank you, Honorable Ntate Matias. Ntate Matias. The Honorable Bautapa. Bautapa. Akbare Briet.
Thank you, Chairperson. I'm covered.
Honorable Brett Danke. The Honorable Trader. The Honorable Trader. Honorable members, any other honorable member on the platform who may wish to pose a question? I've not recognized.
Chairperson.
Ndabezit, Kosenkulu.
Although I don't have a question, Chairperson, but I wanted just to say just a few things. It seems, as the Minister has just elaborated on the issue, that the fact was around the formation of the trust, which we are currently talking about, which was legislated by the National Party government and was amended by the current government. You know, Chairperson, the issue now has been around why KZN King has that trustee status in the land under Mazulu or KwaZulu government, part of KwaZulu government, as I should say. Chairperson, if one may go back to some talks from Senator Mokosi, or even the kings, as just been said, that the kings from other provinces would wish to be treated as the same as KZN. Forgetting one thing, that it is former KwaZulu government, or Eastwhile KwaZulu government, that sort of took initiative to form the trust, not that it was a matter of the national government that did so. The minister in her presentation or briefing was that the intention firstly was that the late king wanted to meet the president following the promise the president made when he was in Richards Bay. It was towards the election at the time, where he committed himself, but verbally, and he couldn't come up with a written position on the promise that he made, that the panel that was led by former President Motlanthe had to retract from what they said, that Makos were just tin pot dictators in the land. And all of a sudden now, the president then decided to delegate to the team of the ministers to deal with the issue, which one has not heard whether that delegation ended up meeting the king and heard the views of the king on the matter, or maybe they did not, as maybe the minister just said, they did not end up meeting with the king and heard from him what his views were regarding the Ingonyama Trust. It's not a question, but a comment, and the understanding, Chairperson, that, or I should say my understanding, if the pressure was around the funding from the coffers of the state towards the ITP, would have been, in my take, that would have rather gone for
recording in progress,
allowing the ITP to run its matters without being funded by the department. If then a legislation could have been sort of promulgated to assist on that, so that, because there are a lot of land under trust from different groups. Families have their own trust. Some groups, like farmers, do have the trust. Some people have decided just to form the trust and sort of made certain developments in certain areas as independent trusts that are not being affected or affecting the administration of land by the National Department. That will be my take, Chairperson. It's only that maybe one is failing to express himself as far as the far-fetched language is concerned, but I think I've raised my point. Thank you.
Thank you, Honorable Cebekhulu. The Honorable Ntate Masipa.
Thank you, Chair, for recognizing me. Sorry, I was looking at the presentation, but I realized that since we have received the presentation on the gadgets, it was never really emailed to us. Chair, I just want to remind colleagues that when we had the minister here the last time, we also, one of the issues that we raised was the issue that the presentation was too thin. And we were hoping, obviously, that it will be broadened a little bit. But let me sponsor my questions, and maybe the minister will be able to address us on that, on these issues. Ndade Cebekhulu pointed very eloquently that there are trusts in trusts and in trusts. So we have got Ingonyama Trust, and within Ingonyama Trust as a whole, there are a number of families that have built trust on those properties or the land that they own. And in one of the presentation, in one of the items that the minister included during the presentation was that the view was that the government needed to initiate a macro policy and legislative review that will culminate in promulgation of a law of general application that will improve security of tenure across the country. I think this point was also raised by Member Bama. I would like to really get from the minister if there has been legislations that have been or micro policy that have been put together to address this particular point that was identified in the Inter-Ministerial Task Team. The second point is the following that is the last point in that particular slide order. In as far as Ingonyama Trust appeared to experience governance-related challenges, the IMTT took the view that the supervising department, which is Department of Agriculture, Land Reform and Rural Development, had to help Ingonyama Trust to deal with such challenges. I think the question for me that I have got, Chair, is that formulated in terms of how the government is interfering in ensuring that it addresses the governance challenges? What have been agreed to between the department and the Ingonyama Trust around how do we address these issues going forward? As we are seeing in the media, some of the issues that are coming out, and also the issues that Member Bama raised with regards to the board changes what has happened and so forth. So I think for me is the question of how does the minister's department troubleshoot to address the governance challenges that are being raised. The last point, Chair, is that the minister also in the presentation highlighted that at least 2 workshops were held with the board to ensure that there was common understanding on its mandate. Chair, I think the minister might have addressed us verbally on this one. Do we have anything in writing that really eloquently put together the outcome, the time of this particular workshops that the minister eloquently spoken about here in terms of when they took place, the minutes and what was discussed, what was the outcome, and what was expected to happen after this particular workshop took place? Thank you, Chair. That's really my questions that I wanted to sponsor. I know that the PTO, we have spoken quite a lot about it, and if the minister can also update us with regards to that particular litigation. Thank you very much.
Thank you, Honorable Ntate Masipa. The Honorable Sibalko Baudlamin.
Chair, thanks very much and good morning to you and the members of the Portfolio Committee and the department. I must indicate, Chair, that I joined the meeting quite late and could not listen to the presentation, but I've been listening to the comments, and mine is to support, particularly from the comments made by member Comrade Mahlo, and Chair, I will await and support the decision that will be taken finally. And may I apologize to you again and the Portfolio Committee for joining very late. Thanks very much, Chair.
Balkur, Sabulela, Baudlamini, honorable members. I think that is all the honorable members on the platform. Allow me to also take the opportunity to sponsor a few questions and a couple of comments. Since the withdrawal, honorable members, of Advocate Mgwengwe as the minister's representative on the ITB, there has been a vacuum of ministers' oversight for a very long time. What are the ministers' oversight mechanisms over Ingonyama Trust and the Ingonyama Trust Board? And who sits at the board meetings for the minister? Honorable members, it might not be a legal requirement, but it is important for the minister's oversight and has been a practice for many years. If one goes back to the meetings, honorable members, between the 3rd of July and October 2019, as well as early 2020, one will note that there was a time when this committee resolved to conduct oversight visit at the Ingonyama Trust. We planned to meet the board and meet with Amakosi and members of the communities. However, honorable members, it was at the request of the minister that such oversight was postponed in order to afford the minister and the task team an opportunity to intervene and report back to the Portfolio Committee. Apart from the Inter-Ministerial Task Team, which we have been informed that it was set up for preparations of the meeting between His Majesty, the late King Zwelithini, and the President. Can the minister inform the committee what she and the department has done about the many challenges confronting the Ingonyama Trust? Honorable members, this committee and the previous Ingonyama Trust Board had somewhat reached a deadlock about accountability of the trust to Parliament. The Ingonyama Trust Board refuses to account on the affairs of the trust, especially the funds, citing the fact that PFMA does not apply to Ingonyama Trust. It is not listed in the schedules of the PFMA. This committee therefore believes that the trust is accountable on all its affairs to Parliament through Ingonyama Trust Board. What is the minister's view in this regard? When it comes to accountability, honorable members, it will also include the Ingonyama Holdings as a subsidiary company of the Ingonyama Trust. Does the honorable minister think that the current legislation governing the Ingonyama Trust Board and the Ingonyama Trust, i.e. the KwaZulu Ingonyama Trust Amendment Act number 9 of 1997, is adequate to ensure that there is clarity of accountability? We know, honorable members, that for a long time, the ITB had wanted to bring amendments to this legislation. That will be all on my side, honorable members. Allow me to hand back to the honorable minister, the deputy ministers, the DG and officials of the department for responses and comments on the questions posed by honorable members. Honorable Minister Mamutiteza.
Thank you very much, Chairperson and honorable members, for the comments that have been made, but also for an appreciation that the Inter-Ministerial Task Team set up by the President had only one task, which in my view, I would leave it in the hands of the presidency as to how that matter of the meeting with the king then might have been resolved going forward. And I'm happy that Ngosu Cebekulu has also given a context and reflected on the matters as to how all of that panned out, which resulted in the meeting that set up the IMTT. As I indicated, the IMTT's purpose was to prepare for the meeting of the President and Ingonyama Trust. I'm happy that on that one, we are at one. Coming on the other issues related to the board and the engagement between the department and the board in trying to ensure that we do our responsibility on the oversight of the board, whose responsibility is to assist this trustee to manage its task. I'll then, answer those questions. There's a question raised by Honorable Mbabama. How many old members are in this new board? There's only one, Advocate Linda Zam. And I would like to remind members again that when we had to fill in the vacancies in the board in 2020, in consultation with the Premier of the province, Chair of the House of Traditional Leaders of KwaZulu-Natal, and the King, we agreed on filling those positions with Advocate Linda Zama and Ms. Kunta, who is a chartered accountant. And in terms of the new members, therefore, Advocate Zama is the only person that has remained. And just to correct Honorable Mbabama, the previous deputy chair was Ms. Kunta. So she has never been the chair. She has only been appointed now to be the chairperson to the chair nominee that has been made by the King. In respect to the panel, and I would like to again remind honorable members, the way Parliament dealt with the recommendations of the panel, and I'm sure you can go back to the archives, The Speaker actually sent that report to all portfolio committee members, portfolio committees rather, who were impacted upon by that report for them to process the recommendations. And that happened in the 5th administration. What I wouldn't know is how this committee has taken up those matters arising out of the Motlanthe report. But as I say, you can go back to the archives. All committees that were affected by the report, where there were recommendations, were given to the portfolio committees to process and report to the House chairperson responsible for committees on how they're going to address those matters going forward. At least I still got what you call historical knowledge, because I was a House chair at that time in the 5th administration when this matter was dealt with. And just to indicate again, Honorable Mbabama, the Inter-Ministerial Committee was not going to have the power of deciding whether the board is nullified or not, or even the legislation, because that's not, and it was never their mandate. The legislation of Ingonyama Trust clearly outlines how the board must be appointed. With respect to the legislation, whether that legislation is repealed, it's actually a matter of Parliament. If this committee would like to make that recommendation arising on how it is dealing with the Motlanthe report, that will be the decision of this portfolio committee as legislators. But it wouldn't have been in any other way a decision of an Inter-Ministerial Task Team. With regards to the broader issue of communal or customary land tenure, that's the matter, and we've been reporting in this portfolio committee, starting with the study tours that were done, led by the 3 deputy ministers, Deputy Minister Skwatsha, Bapela from Kokta, and Justice, culminating to the provincial consultations with communities and the House of Traditional Leaders in the provinces, which finally culminated in the summit held last year in May. That was part of the work of finally dealing with the communal land tenure issue in South Africa. Following the summit, the department has been working on a legislative review. That legislative review, first and foremost, takes into consideration the preliminary work that was done in the mid-2000s, which finally culminated in CLARA, which is the Communal Land Rights Act, which then, as we know, after having been passed by Parliament, there were certain sections that the Constitutional Court actually struck off and said must be reviewed. That case was brought by some members of the community who felt, particularly in the governance structures, there was not balanced representation. It gave more powers to traditional leaders. That's why CLARA actually, part of its sections were struck off, and there was no amendment, therefore, that followed. Also, you have got other legislation that are currently there of an interim nature, such as the PILRA, ULTRA, and others. So that legislative review takes into consideration of all of those processes and will go to cabinet and then to this portfolio committee in terms of tabling in Parliament. This year in April, a multi-stakeholder workshop was held to look at the draft that the department is presenting. So that's work in progress in respect of the law of general application in respect of tenure security. There has been other views, particularly that emerged from that workshop, that we don't need to address only communal land tenure, we also need to deal with all tenural systems so that even people who live in informal settlements and in the peri-urban areas, their tenures must be equally secured. So I just want to clarify that those matters are being dealt with and are undertaken. View of the minister whether the new board is up to the task, looking at their skill set, what they bring and what they will bring in this process, I am confident that they'll be up to the task. Obviously, the pudding is on the detail, is when that committee starts to work, that all of us will be the judge whether it's doing what it's needed to be done. Honorable Mandela, on the issues that, or maybe lastly on the issues raised by Honorable Mpapama about the treatment of Ingonyama yaKwaZulu vis-a-vis other Okumkani, Nenkosi in other provinces who are of that same stature. I think again, Inkosi Tebekulu indicated and gave the historical view of how Ingonyama Trust came into being. However, if in the new legislation, there is a view that society and including these legislators seated here feel that there must be particular status accorded to kings and Okumkani in a particular way, whether they must be funded in a particular way. Again, it is not a matter that can be decided by the executive alone. It would include the legislatures, but also broader societal consultation. The matters related to what Honorable Noko says, that the committee last, when it met, it said the report was thin. I don't remember it. My recollection was that members of the committee felt that they had just received a report, they've not been given enough time to look at it and respond. And just to indicate to Honorable Masipa, there was no way the report would have been bulky, because it was answering to the question of the IMTT, its mandate and what it was supposed to do. But in respect of the matters Honorable Masipa says, the issues we are reflecting on the report about the work they've done in the workshop, that has been part of the executive action and the responsibility that the minister must undertake. I'm not sure whether in that response, or rather in that work, the executive is expected to actually give the report on minutes of the meeting with the institutions that it's overseeing. If that is the request, I think it will be a new request from the committee. Surely we will comply with that. But I'm just saying that when we do our executive, function in overseeing entities and institutions, we will intervene as and when we need to intervene, because that's the responsibility we have in terms of ensuring oversight to those institutions. With respect to the other matters that has been raised by Inkosi Mandela, recalling the reason why the committee could not go on the oversight on the time, indeed, one has responded to it, to what had happened, and therefore how we are going with the matters going forward, and what the committee had said about how these matters by the line function department must deal with. And Chairperson, it is these matters, as you know, that there was a particular time at which we had to hold the budget of Ingonyama Trust, because indeed we were not convinced that they have done what they needed to do in terms of their responsibility. It was for that reason that we never argued for the increase of the budget of Ingonyama Trust Board, because in our view, we felt that that budget was adequate for it to do the task that they have to do with the board. All of those have been matters of governance that we have been dealing with in addressing the matters that are there in Ingonyama Trust Board. As the Inkosi Mandela indicates himself, there is no requirement that the minister must have a representation in the board. However, to make sure that there is better appreciation of how the board is dealing with the matters, we usually have somebody who sits in the board to ensure that, you know, that person is a ministerial representative. It's not only in Ingonyama Trust board that we do, but the role of those members are very clear. They would never take decisions, for instance, as expected by board members who have got the fiduciary duty in terms of why they are appointed in accordance to the statute. So when Mr. Mgwengwe left the department and was appointed full-time by the board, we did not second anybody to sit on the board. We would engage directly with the board, as you know that on time and again, we've been engaging with the board, expressing some of our concerns in the manner that things have been happening in that institution. And it was for that reason that we actually felt we were shortchanged when Inkosi Uzwelithini passed on, and there were all the matters that were there, which all of us know, which inhibited us to actually appoint a new board. And we're glad that finally now we have closed that gap, which will ensure that the department can engage better with a duly legislative structure that is appointed. In respect to what is the view of the minister about the accountability of the board in respect of Ingonyama Trust holdings, our view has been that that is the creation of Ingonyama Trust board, and therefore it has to account to Parliament. I was sharing with members of the board a matter that you yourself know, which the Auditor General even at some stage presented to this portfolio committee, of the work that the Auditor General have been engaged with particularly the chairperson of the then board in respect of its accountability, particularly of Ingonyama Holdings. And our view is that the new board appreciates very well what is the expectation of the minister about issues of accountability of the Ingonyama Trust Holdings and Ingonyama Trust Board on the resources of the communities and how those must be expanded. And that is why I said in that report that one of the responsibilities of this new board, because the old board did not do it, is to have clear policy for disbursement. And just to indicate to honorable members that the department cannot do that is the responsibility of the board, who in terms of the law is the one that must oversee the work of the trust. Secondly, in respect of the issues relating to the litigation, in the presentation we've indicated where those processes are. As much as the minister, and I reported to this portfolio committee, had written to the board advising it not to contest the judgment, the board as a juristic person felt they needed to appeal the judgment, and I could not, as a minister, stop them to do so. I advised them and stated my reasons as to why I thought they needed to comply with the process. And we're now waiting for the Supreme Court of Appeal to make its judgment about that appeal that was made by Ingonyama Trust board. And I hope the new board will take its view after that judgment, how they deal with the matters going forward, but they know fully well, rather, what is the view of the minister in that respect. Thank you very much, Chairperson.
Thank you, Honorable Minister Mama Udidisa. Honorable members, that is the responses from the Honorable Minister on the Ministerial Task Team that was tasked to look into the matters of Ingonyama Trust. Any follow-up questions, Honorable members? Honorable Mbabama.
Thank you very much, Chair. I think it is clear what the Minister has said, and I am very grateful to her for the advice that she's giving us as a committee. Because really, you know, I was here in the 5th Parliament, and we did not really interrogate the high-level report and the recommendations therein. Maybe in terms of the Ingonyama Trust, this is an opportunity for ourselves as a committee, through you, Chair, to actually go to the high-level report, especially as it talks to Ingonyama Trust, and see what we can do around that. And I appreciate also the input from Utata Inkosi Ucebekhulu around the history. I thank him for that. And I realized that the Zulu nation actually formed their own trust and cannot be now, you know, held to ransom because they had the what is the English word for it? But the fact that they did their own trust. But I think what is the bone of contention is the money, the 23 million that is going to them and not to other kingships, not necessarily the trust itself, but the support that is coming from government in the form of a couple of millions of rands. So, Chair, maybe I will throw it back at you and say maybe we should be looking at the high-level report, send it back to you and my colleagues, and really see what we can do around that. Thank you very much, Chair.
Thank you, Honorable Mbabama. Any other follow-up questions, honorable members? If not, let me also emphasize and welcome Honorable Mbabama that the birth of Ingonyama Trust came as a political compromise 3 days before we went into elections for the first time in our history as a democratically free South Africa. On the 27th of April, 1994. Ingonyama Trust is born through an arrangement between Unkosi Buthelezi and the then President of the Republic of South Africa, President de Klerk, on the 24th of April, 1994. And we have been subjected as the democratically free elected government to carry on an agreement that was reached then. And going into 30 years of our democracy, I've continuously asked a simple question. Has the Ingonyama Trust been a success in terms of its implementation in administering land in KwaZulu-Natal? If the ministry is able to attest to that it has been a success, when is the ministry intending to implement this in other monarchs, that being in other kingdoms? As being South Africa, we are not a one monarch state. We have multiple monarchs that reside within the Republic of South Africa, but are not being afforded the same budget that the Department of Agriculture, Land Reform and Rural Development see fit every financial year to dispose of taxpayers' money, 23 million rand, to Ingonyama Trust Board. And we have said repeatedly, if this is a success, then other monarchs such as the reigning queen of Balobedu, Queen Mjaji, should be afforded the same. King Rabulane of the vendors must be afforded the same. King Mabena of the Ndebeles must be given the same. King's Kukuni of the Bapedi nation must also be afforded the same. King of the Mpondomises, who has just been coronated, should also be afforded the same. The king of the Bondos must be afforded the same. The king of Abatembu must also be afforded the same. And the king of Amaxhosa must also be afforded the same, so that we can be able to say as a committee that we have seen a fair and equal recognition of traditional leaders right throughout our landscape of our country. And there is no one monarch being elevated above the others. In the struggle for liberation, if you study the role of our traditional leaders and those that formed the first prisoners on Robben Island, you will come to the realization that it was a front fought by Amakosi. And to elevate one above the rest is a totally injustice to our nations and the beautiful diversity that we have as South Africans on this beautiful land of ours. But that conscious, honorable members, will sit within you and within the leadership of the department. We can only point a horse to the river, but you can never force it to drink the water. And therefore, this matter will reside within the many administrations to come. And we hope that the conscious and the betterment of it will find room in your thinking to ensure that all our traditional leaders are treated the same. We will not dwell in the other funds that are afforded to the monarch in terms of the provincial budget that is being afforded outside the 28 million that this department gives to the Ingonyama Trust. That would be all on my side, honorable members, and I do hope that as we come from various provinces as members of this committee and live and reside under different monarchs, we will continue advocating for the equal treatment of those traditional leaders and the role they played in paving our way to this democratically free country we live in today. I see the hand of the Honorable Minister, Mamutideza.
Yes, Ndabezitha, I was just going to say, maybe before you summarize, just thank you and thank the committee for allowing us to make this presentation. We will be guided by you as to how, on this broad matter, you would want to deal with it. And if I were to give a little bit of an advice, it might be necessary to have the committee maybe reflect together with COGTA, because I think these are the matters that would straddle, I mean, the broader questions that you are raising, Chair, between these two portfolio committees. And also in terms of the, you know, how you would want to guide going forward, because some of the matters are beyond us, will require maybe interventions by legislation, by Parliament on how they are taken forward. Thank you very much on my side, Chair.
Thank you, Honorable Minister. Umamumba Bama. and honorable members. This matter will reside with yourselves, and we will look through the Secretariat, the content advisors, and our researchers to see as to how best to assist in channeling this to the legal advisors to Parliament, so that if there's any change we need to effect in the trust, we can be able to do the necessary amendments to cater for all other traditional monarchs in this beloved country of ours. With that said, honorable members, I think I had not taken up reasons for the rejection of the motion of desirability, as we needed to have that captured as well in our report that we will be tabling before the committee. I will therefore look to Honorable Kabe in terms of the reasons provided for the rejection of the motion of desirability, as she was one of the four hands that we had noted. And perhaps if other honorable members that rejected the motion of desirability also want to give reasons for their rejection, we would want to capture that. Honorable Kabe.
Thank you, Chairperson. And let me appreciate the opportunity. Chair, without going back to the initial deliberations, if I may, I want to indicate, Chair, that Honorable Swart, who sponsored the bill, and some of the submissions that the committee is aware of that are in support of this bill have stated that there's no testing of cosmetics on animals that is taking place currently in South Africa. And therefore, Chair, the bill may not achieve its intended purpose, according to me, if it does not cover the important products as well. And this has came up on many issues that we highlighted, especially when we were talking about the impact on trade. And this, Chair, had potential also of threatening the relations that we have on trade. If I take the members back, Chair, you remember that we were saying we're focusing inside the country if we have to, but what about those that are being brought into the country? Are we not disadvantaging our local businesses? Is it in our interest as this committee to squash more business initiatives in this country at this point where economy, even worldwide, is not doing well? Now, as we operate, Chair, like I'm saying, in a global village, and also considering some cosmetics companies are operating that are operating here in South Africa are multinational companies. A ban that is limited to testing within our borders here in South Africa may disadvantage our local business, while allowing multinational companies probably to thrive, even retailers to import similar products into the country without restrictions on animal testing. Because as the presenters has indicated, from the Department of Agriculture to these departments, we don't even consider what is being brought into the country. And here we're not manufacturing still anything that is tested on the animals. So why would we want to take ourselves into something that is not even in existence? I was saying last time, Chair, when I was talking in this committee, why do we want to be preemptive with the load that we have? For an example, we're having so much pressure on foot and mouth disease. Let's focus on the challenges at hand and not want to go into something that does not exist. And if it does come at any point given in time that we would need to do something about it, if it rears its ugly head, the minister has got powers or will have powers to remedy it through regulations. And that is my take, Chair. Or in a resource-constrained country like ours, including the strained justice system, the objects of this bill may not provide a significant benefit to this country, but a negative impact, in fact, on employment in the local cosmetic industry. The presentation was saying there's also impact on our retail system. So considering that we are talking about an amendment in Act 1962 in 2023, and in light of the numerous issues, including advances in animal welfare that has been highlighted through some of the submissions, it makes sense that instead of a piece of meal approach that Honorable Sipa was even saying at some stage, why don't you go to this old piece of legislation and do an overall kind of a thing? Deal with the whole thing, not piecemeal approach. Then it would at least make sense. So for me, Chair, those will be my reasons. I'm objecting to this based on this that I've just indicated. We're having so much challenges as this sector. There are issues that we want to deal with. Honorable Heron, I even indicated last time, he was saying when we were dealing with other legislation, have we considered even engaging the NCOP on these bills that we are passing, if they will be able to process them, or are they going to lapse again? So why would we want to take something that is far-fetched? Let's consider the workload that we have, challenges that are at hand, and leave this thing for now, Chair. The legislation that is protecting animals, we are concerned, as and when this has to arise, then the minister will have powers to curb it with or to regulate it through the regulations. Thank you, Chair.
Thank you, honorable members. That covers the reasons for rejecting the motion of desirability. Any further rejections or reasons for rejections? Thank you, honorable members. I see the hand of Honorable Kruger. Honorable Kruger.
Yes, thank you, Chair. I just want to correct my colleague that just spoken now. It was not Honorable Heron that's talked about NCOP, but it was myself. So if they can just note it correctly, thank you.
Thank you, Akbar Kruger, for highlighting that. It shall be noted.
My apology,
members.
Chair. My apology. I serve in too many committees. Sorry, Honorable Kruger. I wanted to say Honorable Kruger.
No, noted, Honorable Kabe. Honorable members, that is all that was on our agenda for today's session for our portfolio committee meeting on agricultural and reform and rural development. We will request in terms of the Animal Protections Amendment Bill that the Secretariat and content advisors as researchers do capture the deliberations by the portfolio committee and do put together the report so we can bring it before the committee and send it to the National Assembly. Honorable members, this brings us to the end of our meeting. I'd like to remind you that we do have a three-line whippery at 2 o'clock this afternoon. We look forward to seeing you in the plenary, but also we have, yes.
Yes, sir. Don't forget about the ARC nomination report, Chair.
Yes, thank you, Mamukakaza, for the reminder. We had been requested, honorable members, to make a submission of names to the ARC, which we received only one name from the Honorable Klappe, which was sent to the ministry by the Secretariat on the names that came from the committee. That opportunity closed last week. I think it was on the 26th. So we have exhausted that aspect. Now there's a full report in terms of this ARC, and I will take the opportunity just to read it out for honorable members. The report of the Portfolio Committee on Agricultural and Reform and Rural Development on the nomination of candidates to serve on the board of the Agricultural Research Council, being the ARC, dated the 6th of June, 2023. The Portfolio Committee on Agricultural and Reform and Rural Development, having considered the request by the Honorable Minister of Agriculture and Reform and Rural Development to the National Assembly to nominate suitable candidates to serve on the Board of Agricultural Research Council, ARC, referred to it on the 17th of May, 2023. See referral document dated 17th May and letter from the Honorable Minister of Agriculture and Reform and Rural Development. Reports as follows. 1, the process for nomination of candidates. The process for nomination of candidates to the board of an entity by the committee entails the formal tabling of the referral to the committee, which must include the accompanying letter from the minister detailing the nature and the number of vacancies that needs to be filled and what is expected from the committee. On consideration of the referral, the members of the committee are then requested to submit CVs of suitable candidates as legislated in Section 9, subsection 3 of the Agricultural Research Act number 86 of 1990 as amended, including other required documents as outlined in the referral for consideration by the committee. The committee will then formally consider the submitted CVs of nominated candidates to ensure that they meet the requirements as legislated in section Can you move up? Seems we've lost the place we were at. Okay. After the selection of the qualifying candidates, the committee adopts the report that will be sent to the office of the speaker with the relevant CVs and documents of the qualifying candidates for submission to the minister. 2, the committee's decision and resolution. The letter from the Minister of Agriculture and Reform and Rural Development that was sent with the referral to the committee was dated 25th April 2023. However, it was only referred to the committee on Wednesday, 17th May 2023, 2 days before the due date of 19th May 2023. As the committee generally sits on Tuesday, it only managed to consider the referral on Friday, the 19th of May 2023, which was the due date. The committee therefore could not proceed with the nominations as per the usual process outlined in section 1 above. The committee resolved that interested members of the committee can still nominate as individuals qualifying candidates and submit the required documents to the committee secretariat by the end of business day at 4 o'clock for a direct submission to the minister. One nomination was received from the Honorable MP Klape, and the CV of Dr. Poncho Jarias Makaila was sent directly to the minister's office. Honorable members, that's the report to be considered. Thank you. That will be all honorable members in terms of the nominations for the nominations that were put for the ARC. Honorable Kape, I see your hand.
Yes, thank you, Chair. I just wanted to correct the spelling on the surname. It's Poncho Jarias Mokaila, not Makaila, Mokaila.
Mokaila.
Yes, Chair. Thanks.
Thank you. If you can also send it to the secretariat, and then they can be able to effect it correctly. But let us note the surname spelling needs to be corrected, and that would be all honorable members in terms of the nominations to the ARC. This therefore concludes the work of the committee. Yes, Ma'am Kakas.
Move for the adoption, Chair, of the report.
Oh, let me move for the adoption. Let me put the report to the committee for its adoption, honorable members. Honorable Kape.
Chair, I move for the adoption of the report for submission of the name of Dr. Poncho Jarias Mokaila as a nominee for candidacy in the ARC board. Thank you.
Thank you, Honorable Kape moves for the adoption of the report on nominations through the ARC board. Any second, honorable members, for the adoption of the report regarding the nominations to the ARC board?
Mahlo Patricia, second for the adoption of the nomination.
Thank you, Honorable Memasho, for seconding the adoption of the report for the nominations of the ARC board. Honorable members, that brings us to the end of the work we envisioned for today. And I wish you a beautiful day ahead and a great week ahead. Do enjoy it and spend it constructively in the work that we do. The meeting stands adjourned.
Thank you, Chair. Thank you, Chair.